if we try to summarize then some of the key issues and actions for businesses need to apply, this slide tries to do that. So taking each of those movements in turn and summarizing that for you. So on Northern Ireland to GB movements, it's important to note that there'll be a requirement then to file customs declarations on those movements between GB and NI. So it's important to understand with your suppliers who will be responsible for filing those declarations. Ordinarily, it would fall on you as the customer, as the recipient in Northern Ireland, to file those declarations, and those declarations will be submitted through the TSS service. So again, if indeed you haven't registered with the TSS, please do so now. And you'll also be required to get comfortable with the at-risk test. Now, obviously that at-risk test hasn't been confirmed as yet by the Joint Committee. So please bear that in mind when you're planning for those scenarios in terms of those GB to NI movements. In terms of the VAT side of things, certainly things are more simplified with the announcement of the HMRC. So in terms of sales between Northern Ireland and GB, VAT continues to be chargeable, and it's the same on any purchases from GB into Northern Ireland. There is a change in terms of movement of own goods. So movement of own goods from Northern Ireland into GB, there's no VAT to be accounted for, whereas GB to NI, movement of own goods, VAT is to be accounted for. And again, as I said previously, that VAT that is to be accounted for on the movements between GB and NI is simply, on most occasions for businesses where they're fully taxable, a VAT accounting entry. So you should consider whether your systems need to be updated in that regard. And indeed, there's obviously changes with VAT grouping where you have different establishments in GB, which we covered earlier on. On those NI to EU movements, they remain largely unchanged. B2C supplies will change from July 2021 in terms of those distance sales to private individuals within the EU. The EU is simplifying matters for distance sales, meaning that there should be one VAT return to be filed with HMRC for them to remit tax in the various different jurisdictions to where your customer belongs there. In terms of GB EU movements, these will be treated as exports for VAT purposes. So again, where you're sending goods out, those will be exports for VAT purposes, generally zero rated. Where you're receiving goods into GB, postponed VAT accounting will be applicable. So again, any import VAT payable on those goods that you bring in from the EU into GB, you can account for the VAT under that postponed VAT accounting. Again, for most listening, that should be a nil net effect. It's a simultaneous input VAT deduction there. So that's a welcome news instead of having to pay that import VAT at the point of entry into GB. And again, that import evidence, those formal customs declarations will be required to allow for that import VAT deduction. And it is important to note that HMRC require the business that is incurring the import VAT to be the legal owner of the goods to be able to deduct that import VAT. So that's important to note when you are indeed importing into GB. And we have seen increased activity from HMRC on that point in terms of the legal owner. In terms of your Interstat declarations, there'll be no requirement to file your Interstat declarations where you're dispatching goods out of GB into the EU, but you will be required to continue to file your Interstat arrival declarations for the year 2021. Where indeed you are sending goods from GB into mainland Europe and further, there potentially, as we said, there could be a loss of some VAT simplification, such as call-off stock, for example, which may require then an overseas VAT registration requirement and you having to file those VAT returns in those local countries. And it is important to note that where you trigger those overseas registrations, on occasion, some European jurisdictions do require fiscal representation in that regard. Turning then to services, again, largely unchanged, and it really is for services in certain industries a regulatory matter to consider. There are certain things that will change in terms of the MOS scheme for digital services provided to private individuals. So if you are in that space, the key action there is to register with other overseas jurisdictions to be able to remit those taxes. And indeed, digital service and electronic services provided to business customers because of the use and enjoyment provisions, because the UK will be a non-EU territory for VAT purposes on services, you will be required, if you are in that space, to familiarise yourself with these use and enjoyment provisions that can shift the VAT place of supply to other jurisdictions within the EU. So VAT actions and next steps then. So please do update your supply chain review if you haven't already done so. It is worth considering overlaying some of the VAT consequences of that, and to a certain extent, the recent HMRC publication has simplified things in terms of providing clarity on some of those movements for VAT purposes. So please do update your supply chain review and overlay the VAT consequences. There may be instances again where you have that GB movement and that potentially there is that overseas requirement because of the loss of EU simplifications, unlike Northern Ireland, which will follow EU VAT rates or VAT rules, sorry. Obviously, ERP requirements, particularly in regards to whether you're involved in the movement of own goods, for example, from GB into Northern Ireland, again, as was said previously, there will be that requirement to account for VAT on those movements, which is, as I said, in and out for most. But if you can indeed update those your ERP systems to automize that would be helpful in terms of recording that movement. Obviously, commercial decisions need to be made in terms of importer of records where you are importing into GB or indeed where you are availing of the TSS. Please do ensure that both your customers and your suppliers are aware of what roles they play within the supply chain. Ultimately, we don't want goods being held up at borders and delays there where businesses aren't fully aware of the requirements under the Northern Ireland Protocol. So as we have seen, things can change pretty quickly in this Brexit space, particularly with the Northern Ireland Protocol, given its unique standing. And we've seen that most recently with the latest publication on the 26th of October by HMRC on the VAT side of things. So please do keep up to date in terms of these publications and the announcements. It is easy to sign up to .gov.uk for Brexit announcements, and you will get email confirmation of any changes. So please do sign up to those. It's important to keep it in contact with this and up to date in terms of these changes, because it can and will change rapidly to the end of the year there. So thank you for listening. I hope that you found that useful. Thank you.